Hi, welcome back for another Z Talks. I'm Keeley Mitchell, the founder of Z Living, the premier consulting firm that provides legal and business advisory services exclusively to the yoga and wellness community. Well, I am busy getting ready to go out to California tomorrow morning for the Faith Awards where I'm presenting at. So I'm so excited. Yay! And it'd be nice to get some California sunshine since I'm here on the East Coast and fall and chilly weather are fast approaching. But before I headed out to California, I wanted to get to you guys another Z Talks where I provide some great tips for running your yoga or wellness business. So, what I want to talk to you about today, I want to talk to you about how often small business owners erase the protections that are afforded to them by incorporating or forming a limited liability company. And what do I mean by that is we form corporations or limited liability companies or another type of company. There are others out there that provide protection for limiting your personal liability. Uh, in order to protect your personal assets. And there are often times that there's steps that small business owners take that actually erase those protections. So I want to make you aware of that so you're very careful not to do these things, or if you have to, be aware of the consequences. So the most popular way that small business owners erase their protections is commingling the funds. And I know oftentimes it's hard out there. Your business bank account might have more money in it than you say your personal checking account. But using the company credit card to go shopping for clothes or your grocery shopping that's not related to your business can actually endanger your protections and actually get them removed. And what I mean by that is, say that should something arise that lands you in court and you kind of wave your hand and say, dear judge, I formed a corporation or a limited liability company, so you can only look to my company to satisfy my legal obligations or my company debts. And if the court reviews documentation that shows that you are actually using company funds for personal matters, they might do what's called pierce the corporate veil. And piercing the corporate veil means they remove the protection, and so they can go after your personal assets. So you've got to be really careful about commingling funds because you don't want that to come back and bite you. So another popular way that small business owners end up erasing their protections is signing a personal guarantee. So when do personal guarantees come into play? They often come into play when you decide you want to lease space or borrow money. Landlords and lenders will look at your company, and if your company is relatively new and has no credit, they're going to turn to the owner and say, hey, can you personally guarantee this lease or this loan? Because you probably have more of a credit history than your company does. And small business owners are often in a rock and a hard place because they want the space or they need the loan to run their business. And so they're going to have to sign that personal guarantee. And it does make sense from the landlord and the lender's perspective because they don't know how reliable your company is. So if you're in that position, what do you do? The first thing I suggest is plainly asking, can they get rid of the personal guarantee? Some lenders and landlords will get rid of it. Others won't. So what happens if you're dealing with the lenders and the landlords that won't? Well, there's two things I suggest you do. One, ask there to be a cap on the amount of money that you would be responsible for under the personal guarantee. So for example, say that you put in the personal guarantee, you'll be responsible up to $20,000 of the company's debt or legal obligations. And that might work for the landlord or the lender. They might say, okay, that's fine. At least we know you're responsible for part of money that might become owed to us. Another option is putting a time limit on your personal guarantee. So if you say to your landlord, for example, hey, I am taking out a 10-year lease on this space. And after 5 years, if my company has paid you on time, you haven't had any problems, I'm in good standing under the lease, why don't we make that personal guarantee go away? My company has proven itself. And so that might be a way to kind of limit your personal exposure. So there you have it. Be careful with your personal guarantees and commingling funds, because there are ways that you can remove the protections that you worked so hard to get by incorporating or forming your limited liability company. So there you have it. That's the topic today for Z Talks. I hope you join me again. I hope to report from the Faith Awards this weekend and kind of get up a new video from there. And if I'm unable to, I will definitely be back next week for another Z Talks. If you want to learn more about Z Living, please go to www.zliving.com. That's ZILIVING.com. And when you get to our website, sign up for our newsletter, which I send out with more wonderful tips and updates that will help you run your business and make sure that it's legally and financially sound. Also, read my blog. I have a great blog on there that provides tips as well. And of course, if you ever have any personal questions about your situation or need any assistance, definitely reach out to us. All right. I hope you guys have a wonderful day, and namaste.